on Law Weekly, we bring you some of the discussions from the Nigerian Law School Alumni Lecture of the Class of 77. The class celebrated 40 years of their call to bar with a thought-provoking lecture titled, "We are lawyers, we are judges, now justice." A former Director General of the Nigerian Law School, Dr. Kole Abayomi, chaired the lecture, which held at the premises of the law school in Lagos last weekend.
As new weeks on July 1, 1977, it was unlikely that any of us gave serious thought to what the next 40 years will portend for us. And that was not unexpected, as most of us were barely above the half of that number of years in age. Now, as senior members of the bar and the bench, and confirmed parents and grandparents, we can look back with better understanding of what the profession of law is all about.
That was how Dr. Larry Onodeko started the anniversary lecture of the 1977 class of the Nigerian Law School. Members of the class, their friends, families and other professional colleagues converged on the Lagos campus of the school to commemorate their 40 years of being called to the bar. It's a reunion they have all looked forward to. The class has an array of accomplished members. It boasts of 3 serving justices of the Supreme Court, 3 justices also of the Court of Appeal, several serving and retired chief judges, and of course several serving and retired judges of the federal and state high courts, as well as several senior advocates and many others who have distinguished themselves in both the public and private sector of the economy. The opportunity of the anniversary is one they have seized to take another look at their profession, and this lecture delivered by their classmate Dr. Onodeko is aptly titled, "We are lawyers, we are judges, now justice." The senior advocate focused on the role of lawyers and judges in the attainment of justice, especially in the light of the enormous powers and responsibilities entrusted to them by the Constitution.
From the perspective of the non-lawyer, can we lawyers comfortably say that we have earned the reputation of reasonable compliance with promoting and fostering the cause of justice? Is it not correct to assert that many of us have commercialized and monetized the cause of justice? In my early years of practice, I often wondered if some of the pursuits of lawyers, especially in the courtrooms, were in consonance with the doctrine of and the quest for justice. Many of us will recall those that cited non-existent authorities and principles of law, and those that kept appropriate authorities away from courts, all the quest to be adjudged winners. A green list of legal practitioners have over the years been disciplined by the Legal Practitioners Disciplinary Committee for breach of rules of professional conduct. The conduct of a legal practitioner may well be within the boundaries of the RPC or on its borders, but may still be calculated to defeat or delay justice. It will appear that in growing number of cases, the Supreme Court of Nigeria has been constrained to comment on the attitudes of some lawyers, suggesting a disconnect between the rules of professional conduct and advocacy tactics and strategy. Typical examples are applications for adjournments designed to delay trials and the now ubiquitous applications for bail predicated on ill health, mainly in high-profile cases.
The issues were then passed on to an erudite panel of discussants, moderated by a revered former Director General of the Nigerian Law School, Dr. Kole Abayomi, to provide diverse perspectives to challenge thinking and action. Another lecturer prefers some solutions.
You remember what Lord Denning said, I think in his Discipline of Law, one of those books. When a tourist arrived in London and hailed a black cab and asked to be taken to the Court of Justice, and the man said, "Which court are you talking about? I know the Court of Law, not the Court of Justice." So there is a rigid dichotomy between law and justice. I'm familiar, of course, with what we teach in the university, in the classes on jurisprudence. What do you favor? Justice according to law or law according to justice? We are witnesses of recent history of what has happened within the Nigerian judiciary. And some of us wondered, if gold rusts, what should iron do? Because when you enter a courthouse, the architecture is such that the judge sits on a higher pedestal vis-a-vis the rest of the court. And the judge hands down judgments which are binding on the lawyers, the client, and society at large. But what we are seeing today are instances of judges announcing their daughter's wedding or the burial of their parents, and some very highly celebrated lawyers trying to offer, shall we say, sobs to Cerberus, so that the scales of justice might be tilted in their favor. The presumption is that everybody will be equal under the law, and the judges are sworn to do justice to all manner of persons without affection or ill will. But some of us now say that perhaps the time is right for Themis to remove the blindfold from her eyes so that she can see that people are not equal, and tilt the scales in order to ensure that people get justice that they deserve.
The professor then went on to the issues of self-determination and restructuring.
The last point I will make in terms of the class of 77, who are lawyers and judges and now are confronting the dilemma of justice, is to make their voice heard on the urgent issue of the day, restructuring. Lawyers can be neutral about what the Nigerian society is seeking for. You must try to understand Nnamdi Kanu. You must understand the Arewa, the Youth Consultative Forum, and you must understand the Oodua Liberation Movement. I don't know why the discussion has been left just to politicians. I know many of the politicians are lawyers, but lawyers must inform the uninitiated about the concept